All rise. This Honorable Supreme Court of Tennessee is now in session. Please be seated.
Welcome to our second argument on our Nashville docket for February. We are honored today to have Justice Bill Coke, William C. Coke Jr., sitting with us this morning. He has worked hard getting ready for this case. We appreciate his effort. We're honored to have him here. We've already finished one case this morning. We're ready for our second one. I think all of you probably heard, if you're going to reserve time, please let us know that when you come to the podium. And with that, Mr. Hibner, you may call the case.
State of Tennessee versus Tyshon Booker.
May it please the court, my name is Jonathan Harwell. With me at council table is Melissa Dorado. We're here on behalf of the defendant appellate Tyshon Booker. If I could reserve 5 minutes of my time for rebuttal. Tyshon Booker has been sentenced to spend the rest of his life in prison for an act committed when he was 16 years old. He may very well die in prison. We had a mountain of information about the tragic circumstances of his life and about his documented potential for rehabilitation, but we were unable to present that to the trial court at sentencing because the sentencing regime gave the trial court no opportunity to consider it. Instead, the trial judge was required to give Tyshon Booker the same sentence that it would have given an adult. And as a result, Tyshon Booker will spend 51 years before he can become eligible for release, which is a harsher sentence than a similarly situated juvenile would receive anywhere else in the country. We contend that this sentencing structure that imposed this mandatory 51-year sentence on Tyshon Booker merely because of the offensive conviction of felony murder is contrary to the state and federal constitutions. I have two arguments I would like to focus on. First, I want to cover the issue, our primary issue, that this case is an application of Graham and Miller. And second, I would like to cover an argument that I didn't really get to last time we argued, which is that even if the court rejects the idea that this is an application of Graham and Miller, that under the analysis of the Eighth Amendment and the Tennessee Constitution, that it is nonetheless an unconstitutional punishment. To begin with the primary argument, the issue that is in dispute between the parties is what sentences trigger the protections of Graham and Miller. The state has not contended in this court that Graham and Miller apply only to those sentences that are called LWOP sentences. The state, I think, concedes that a 1,000-year sentence would have the same trigger of Graham and Miller. And so the issue is, beyond LWOP, what sentences do trigger these protections. And I think maybe I did a disservice to our cause last time in making it sound like I'm arguing based on a single word or a single phrase, the meaningful opportunity for release. Because I don't think it is just a single word or just a single phrase that we are relying on. What we're relying on is a rationale set out at extensive length by Justice Kennedy in the Graham opinion. And when he described as part of how he and the court was arriving at their decision, he described the concern, the problem with the sentences that was being identified. And he talked, yes, about the denial of a meaningful opportunity for release, but that was not a one-off phrase. That was part of the overarching rationale. And he talked in other places in that opinion about this, the problem is the sentences deny a chance for fulfillment outside prison walls, deny a chance for reconciliation with society, deny a chance to re-enter society, to re-enter the community, deny a hope of restoration. And again, in the one that we have cited, denied a meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation.
Well, assuming all that's true, how do we make that work considering Tennessee statute? How do we put that into play?
I think it is, I think Justice Kirby mentioned it's sort of a mushy standard, but it is the one that is given to this court by the U.S. Supreme Court. And in looking at whether it has been met, we think about what a 51-year sentence is. And we think about, is this a sentence that, A, is it one that someone could plausibly survive? And B, is it one that if one did survive it would provide the opportunity for reconciliation with society, for reentry into society, for fulfillment outside prison walls? And that is something that I think truly that's the wisdom of the court, to consider what we all know about life, what we know about someone imagining a 16-year-old going into prison, spending 51 years in prison, and when he gets out, if he beats the odds, becomes the first person that we know of to survive 51 years in Tennessee prisons. If he gets out...
But is that in the record that he would be the oldest one at age 67?
I don't know that there is... I don't know that that's in the record. The state certainly has not cited an example otherwise.
Right. Okay.
Mr. Harwell, you've cited the length of the sentence several times and the fact that there will be no meaningful life for this defendant after release. But we know from Miller that in Tennessee, if the state files a notice of life without parole and proves an aggravating circumstance, as they're required to do, that a juvenile can properly be sentenced to life without parole in our state, correct?
Yes, and that's the issue about Miller. Miller does not say that no juvenile can be sentenced to a sentence that ensures they die in prison. But it does say that before that decision is imposed, there has to be some avenue for someone to consider all of the facts about reduced culpability of a juvenile, about a juvenile's susceptibility to outside peer pressure, and above all about the juvenile's potential for rehabilitation. And so we would be in a much different scenario here if there had been an avenue for us to present that evidence and to be considered, and if it were rejected. But here there was no opportunity for us to use this information. We had a report from Dr. Cruz talking about the PTSD that Tyshon Booker suffered, talking about his life growing up, and also saying there's therapeutic interventions that can work on this young man that will allow him to be rehabilitated.
Well, if our legislature amended our life sentence statute and made it where it was not mandatory, and the state had to file a notice and prove an aggravating circumstance beyond a reasonable doubt, and if that wasn't proven, then it reverted to a 30-year sentence, would that be constitutional?
As long as there was an avenue, not merely for consideration if an aggravating circumstance had been proven, but
there are always mitigating factors.
As long as the scenario allowed all of those mitigating circumstances identified in Roper to be considered before a sentence was imposed, then it wouldn't violate Miller.
So would you be pleased here with a result that simply remanded this case for an individualized sentencing hearing? Is that a possibility? I mean, would that satisfy your concerns if we say, well, this was mandatory, it should not have been mandatory under Miller? Have a hearing and bring in all your evidence.
I think that would be one remedy to the constitutional problem. I think that would run into, in essence, some ex post facto problems in terms of this court rewriting what the legislative scheme would be. And that's the one thing that I think is fortunate for this court, that a lot of the cases across the country, courts didn't have the luxury, which is we have a pre-existing scheme. And the pre-existing scheme of 60 years at 60% with a floor of 25 years, that is one that is constitutional. So I think the appropriate way for this court to rule is not to come up with a new constitutional sentencing structure, but merely to revert to the constitutional sentencing structure that was already in effect before the Truth in Sentencing amendments took away, raised the floor from 25 to 51. Let's go back to the question about how we evaluate whether this sentence is a sentence that triggers Miller. I think the language in Graham is fundamentally about the quality of life that could be remaining for someone at the end of their sentence. It is not about, is there some period of days in which they will breathe air outside the prison. It is about, do they have some quality of life that will allow them to become part of society again?
Well, assuming we agree with you that this does not provide for that meaningful opportunity, what's the most direct path to making our statute comply with the Constitution? Do we have to extend Miller? Do we have to find it's a functional equivalent of a life without parole? What's the best way to do that? Maybe
this may not answer your question exactly. The easiest way is to say this is an application of Miller, that the amendments in the mid-90s that raised the floor were unconstitutional, and therefore we go back to the way it was before. Certainly the court, even if the court didn't find this were an application of Miller, it can reach that same conclusion on a independent cruel and unusual analysis that I will get to in just a minute.
But doesn't, I'm sorry to interrupt you, but doesn't that circumvent what to me is the central holding of the Miller line of cases, and that is that kids are different? And there needs to be more individual sentencing, and you need to make sure that the punishment fits the crime and the criminal. And by looking at the end of the line, you're really leapfrogging over that important question. So how does this decision, while it shortens sentences, how does it help juveniles get individualized consideration? I mean, isn't that driving force behind the U.S. Supreme Court's decisions?
Yes, it is. And
there's no current justice on the court, either in their writings on the court or as judges or in law review articles that I could find, that disagrees with the notion that kids are different when it comes to sentencing.
That's right. And
so why aren't we addressing that rather than just saying let's lop off a few years and say Miller doesn't apply?
Except, I mean, obviously, I would not. I would be open to the idea that any sentencing structure for juveniles should be approached differently. But the real issue is here. There has to be some place for us, for Mr. Booker, to make the argument that he is different, that he is capable of rehabilitation. The current scheme gives him no opportunity. The prior scheme would at least allow him to make that argument to a parole board after 25 years. Some states have provided you can make that argument much earlier. Some states provide you make that argument on the front end, but at the very least, he has to be given an opportunity at a time when release would still be meaningful to make the argument. I have served 25 years. I have rehabilitated. I was not as culpable to begin with, and you, the parole board, should take those factors into account in sentencing me differently than if I were an adult standing before you.
But again, the Supreme Court cases, as I read them, says that the discretion needs to be with the sentencer, is the noun that they use, and a parole board is not the sentencer. The district attorney is not the sentencer when they decide what they're going to be indicted with or charged with. So doesn't the U.S. Supreme Court cases say you need to have discretion in the sentencer?
I don't guess I would necessarily agree with that. That seems ideal in some ways. But many of the states that have adopted Miller fixes have done so on the back end rather than the front end.
And it's very helpful to know what other states did, and there's differences there in terms of the sentences that they were dealing with, the constitutional provisions they were dealing with, and I get the desire to get to the back end of the issue, but the term sentencer is the term I'm taking out of the last 3 U.S. Supreme Court opinions, where they say the discretion should be in the sentencer.
And I guess I don't disagree. That is what the cases emphasize. I think that when you have a situation where there is a reasonable parole review after a certain period of time, the understanding is that brings the case out of the ambit of Miller and Graham, but we're certainly not opposed, would not be opposed to a system, and it's incredibly frustrating to stand before a trial judge imposing sentence, have information that is relevant under all of the factors of the Sentencing Reform Act, and have no way to use it. So in that way, I am agreeing with the sentiment.
You are asking for relief as to all juvenile offenders, aren't you, and not just Mr. Booker? You're asking that the statute be declared unconstitutional, not just in Mr. Booker's case, but as to all juvenile offenders convicted of first-degree murder with no aggravating factors?
I'm not asking that in particular. I think that probably is a predictable consequence of the court's decision. There may be some issue of retroactivity. Mr. Booker is on his direct appeal, and so the issue is squarely presented for him. We've not briefed or argued whether or not someone who has exhausted their appeals. But I would think the consequence, if this court were to find that this regime is unconstitutional, would be that they would be entitled to some relief as well.
How would, if we adopted a remedy as to simply requiring that discretion be inserted into the sentencing decision, how would that affect other juvenile offenders who may already be incarcerated?
I guess if the court's conclusion were that the consideration is on the front end, I guess there would have to be remands for the sentencing judge to consider that information that was never considered before. If the court's conclusion is that it can be considered on the back end, then the statute providing parole eligibility with a floor of 25 years would allow the parole board to consider that information.
So the relief that you have proposed and the state has not agreed that you're entitled to relief, but if the statute is deemed unconstitutional, all the currently incarcerated juveniles would simply, their sentence would in effect be changed without resentencing?
I think that's right. They would be subject to the lower parole eligibility floor.
Okay, thank you.
But if we remain true to Miller, as you're asking us to do, wouldn't we have to find a way to require individualized sentencing after a conviction?
I guess I don't see that as an absolute necessity, because Miller provides that only certain sentences trigger Graham and Miller, right? Only certain sentences fall under their ambit. And if you're under the ambit, then the solution is sentencing consideration on the front end. But if you lower the parole eligibility, then you actually don't, it's no longer a sentence that triggers Miller and Graham. It's no longer a sentence that denies meaningful opportunity for release. And so in that way, it's no longer a Miller sentence.
Because Miller doesn't directly apply here, does it?
It
does not directly apply to Mr. Booker's sentence.
It's our position that it does.
And how is that? Because he got a life sentence, not life without parole.
Right. So LWOP was certainly the factual scenario in Miller. Miller is saying the sentences covered by Graham can't be imposed even in a homicide case in a mandatory fashion. So we look back at Graham to see what sentences Graham was talking about. And in Justice Kennedy's analysis, yes, it is dealing with a life sentence out of Florida in Graham, but all of the description of what was wrong with that sentence is true also of Mr. Booker's sentence. So it's our position, this is not an expansion of Miller, an expansion of Graham. This is the essence of Graham that has been extended to the murder situation by Miller.
Sounds like a functional equivalency argument, or
Yes.
is it?
Yes, this is the functional equivalent of an LWOP sentence for this purpose, for the purpose of are we giving a individual who's sent to prison, are we giving them a light at the end of the tunnel that is going to give them incentive to rehabilitate themselves, to work, to better themselves? This is what Graham is talking about, giving them some reason to change while they are in prison, rather than just having the feeling of, I am here, there is nothing for me else in life. If I could pivot
Mr.
again.
Horvath, before you do that, I want to ask about what impact do you think Jones versus Mississippi has on the issue before us today, if any?
I think none. I think Montgomery, in order to render Miller retroactive under Teague versus Lane, Montgomery sort of worked into a weird position of characterizing Miller as a substantive holding. It was, I think, predictable that the next possible question would be, if you're saying it's a substantive holding, does that mean there has to be an actual finding of incorrigibility on the record? Montgomery said there didn't. The petitioner in Jones said, well, let's go that step further. And the court in Jones said no. But really, and the court in Jones was clear to say this is not impacting Graham and Miller. Those are intact. So I don't think Jones really changes the analysis here.
I'd like to hear you address your second argument under the classic Roper-Graham Eighth Amendment analysis.
And so both under the Eighth Amendment and under the Tennessee Constitution, I think you apply the same test. You apply the Black test, contemporary standards, disproportionality of the sentence, and penological objectives. I would say there is grounds. In Graham and Roper, they characterize this inquiry as ultimately coming down to the independent judgment of the court. And so when you're talking about the Eighth Amendment, that's independent judgment of the U.S. Supreme Court. When you're talking about Article 1, Section 16, it's the independent judgment of this court. So applying the same test for the two constitutional provisions, although different entity exercising its independent judgment. In terms of contemporary standards, in Van Tran, the court looked at sort of a nationwide survey in addressing contemporary standards, and I think we have possibly the strongest imaginable nationwide survey in that nowhere else would someone convicted of felony murder in Mr. Booker's situation as a juvenile be given even above a 40-year mandatory minimum, much less a 51-year mandatory minimum. I think I commend to the court the amicus brief submitted on behalf of the religious groups that speak strongly to contemporary feelings about juveniles and contemporary feelings of Tennesseans as to the potential for rehabilitation. Disproportion to the offense, the second Black factor, and that is one that maybe is not obvious from the title, but is something, as in Van Tran, you're supposed to consider the categorical in this situation, the culpability of the offender. So in Van Tran, it was what can we say about culpability of intellectually disabled people? Here, the question is, what can we say about the culpability of juveniles? This is science that was established beginning in Roper, continued through, we submit an amicus brief about Dr. Gallagher was submitted, bringing the science up to the present. We submitted testimony of Dr. Cruz at the motion for new trial, talking about the unique situation of adolescence where, as he said, the gas pedal is really strong, but the brake pedal is weak. You have the limbic system, the reward seeking, the peer pressure responding to system is fully developed, but those parts of the brain involved in executive functioning have not yet been developed. And so you have this disproportion that produces predictable mistakes, predictable errors in judgment, and that clears up over time just by the way our brains develop. And then, and I've mentioned this a little bit also, the third black factor of penological objectives. And I think the idea that a mandatory sentence is imposed on a juvenile in this situation goes against all of the principles of the Sentencing Reform Act regarding consideration of rehabilitation, regarding consideration of a sentence no greater than deserved, regarding an effort to avoid inequalities in the system. Again, we have statistics from amicus, at least, as to the gross disproportion of racial inequality in imposition of juvenile life sentences. And the final thing I'll say, I know when we talk about Tennessee Constitution, we often want to see a textual difference between the Tennessee Constitution and the federal Constitution to justify any differential treatment if the court were to find the Eighth Amendment doesn't apply. Here, I think there's two provisions, the unnecessary rigor provision and the humane treatment of prisoners provision. We read our Constitution as a whole when we're talking about cruel and unusual punishment. We take into account those other provisions that are unique in the Tennessee Constitution. Very few other states have anything like that. And those provisions talk about that we don't care just what the absolute number of a sentence is. We also care as a state about what happens to the defendant while the sentence is being served, during the service of the sentence. That it be humane conditions, that it not be unnecessary rigor. And I think that is something that is very much at issue here, because one of the problems of this sentence is that Mr. Booker, during this time period, whether he gets out or doesn't get out, he is living without hope. He is living without the incentives to change himself. And so he is being serving a
Mr.
sentence
Carroll,
that is
you
not
need to
humane.
wrap it up. Go ahead.
And I will reserve the rest of my time for rebuttal.
Good morning, Your Honors. May it please the court, Zachary Hinkle on behalf of the state. It's a pleasure to be back with you in person once again. When we argued this case last year, I made two primary points to the court, and they were in brief as follows. First, that this sentence is not the functional equivalent of life without parole, because life without parole sentences, the key characteristic of a life without parole sentence is that it guarantees the defendant will die in custody, guarantees he will never be released, as the court put it in Graham, precludes any hope of release. And that's just not true for this sentence. This is a long sentence, no doubt. But it is a sentence that provides for his release. And so this sentence is simply not covered by the decisions in Graham and Miller. And that brings me to the second point that I made, which is that the defendant is really asking for the court to announce a new rule of constitutional law, an extension of these principles to lengthy term of year sentences that nevertheless do provide for release. And I urge the court not to grant him that extension for a number of reasons, not least of which was that he has been unable to offer the court a coherent constitutional framework for this new rule. In my view, both of these positions have only gotten stronger in the past year. And I'll begin with my first point, that this sentence is not the same as life without parole, and it is not, therefore not covered by the Miller rule, if you will. And I'd actually like to start with Jones versus Mississippi, because I agree with Mr. Harwell that the discrete holding in Jones versus Mississippi about findings of fact is not directly applicable here, although I'll part with him that it has no effect, because I do think the court's holding that there's that incorrigibility is not an eligibility criterion forecloses his argument about substantive unconstitutionality. But I actually think the analysis does quite a bit more than that. And one, I was reading back through Jones yesterday evening, and one thing that stuck out at me once again is that the court says repeatedly that the rule in Miller, which is just a procedural rule, the court tells us, requires that a sentencer have discretion to impose a sentence less than life without parole. The court says that 11 times, some variation thereof. What the court does not say is that the sentencer must have discretion to impose a sentence that provides a meaningful opportunity for release. So that phrase, and the defendant, I think, has has suggested here he's really relying upon more than that. But I see that phrase both in terms of his argument last year and significantly in terms of his briefing as really the linchpin of his analysis. It's nowhere in Jones versus Mississippi. It's just not present in the opinion, either in the majority or the dissent. The same thing is true for Montgomery versus Louisiana. The only time it's mentioned in Miller versus Alabama is in a parenthetical quotation behind a comparison signal. Hardly a sea change in constitutional law that is hiding in one sentence in one opinion that hasn't been repeated since.
Mr. Hinkle, the Jones decision does appear to be a very narrow decision, but what it clearly does is reaffirm the court's previous rulings that youth matters in sentencing and that juveniles must be treated differently than adults. How does our mandatory life sentence that was imposed on Mr. Booker treat him any differently than an adult? That seems to be totally contrary to what our Supreme Court says the law is.
I agree, Your Honor. I agree that the court reaffirms the principle that youth matters in sentencing. I don't think, though, and where I might part with the premise of the question is, I don't think that means that every sentence has to treat a juvenile differently from an adult. I don't think the court has ever held that. And I think we have to bear in mind here that the court is relying upon the proportionality principle in the Constitution, right? That's ultimately what we're talking about. And those are very rarely successful challenges. They apply to a very narrow band of cases. And I think what the court is saying is youth matters in sentencing under the proportionality principle with respect to those sentences so significant we think they are grossly disproportionate, or as the court said in Miller, raises a risk of gross disproportionality.
But how was Mr. Booker's youth, his age, ever considered at any time in his sentencing?
Well, he's in two ways. He's not subject to the death penalty, and that was true as a matter in Tennessee before Roper, because the General Assembly made a policy judgment that juveniles shouldn't be subject to the death penalty.
But this wasn't a death penalty case anyway, was it? So.
No, but I think the point is, how is the state treating him differently?
Okay.
Well, it's subjecting him to a smaller class of sentences, and the most significant sentence that can both statutorily and constitutionally be imposed on him, which is life without parole, that would take, if the state even sought it, would take into account his youth. But I don't think there's any reading of Miller and Graham and now Jones that says the state always has to subject him to a different sentence, that says that there can be no mandatory minimums for juveniles at all.
Seems like a very fine line you're making now, because you've just alluded to the fact that Justice Kavanaugh mentioned 8 times that the discretion is in the sentencer. And that's not the parole board. That's not the district attorney deciding what the charge is going to be, is it?
No, Your Honor, but what Justice Kavanaugh said was discretion to impose a sentence less than life without parole. He never says it must just be any sentence that the judge thinks is appropriate.
He gives a laundry list of options drawn from Sessions' book at the end of his opinion about what states could do. So, I mean, he basically gives the states a smorgasbord of options, doesn't he?
I agree. I absolutely agree, Your Honor. And what he says is that those are questions ultimately of morality and social policy that are decided by the states when they enact their sentencing laws. And so I think what Justice Kavanaugh is saying...
Would you include in that morality and social policy, would you include due process and fundamental fairness?
Sure. I mean, I think he's talking about legislative questions, not constitutional questions. I think due process and fundamental fairness comes into play in every case.
Are you making a policy argument now that these determinations of sentencing and the defendants who are sentenced ought to be left to the legislature and their policy making, not to the courts?
No, Your Honor, and I think, and this might seem a fine distinction, but I actually think that this is a fundamental point to my argument. I don't think it's a choice. I'm not asking the court, for instance, to abstain from deciding a constitutional question. I think deference to legislative judgment in the Eighth Amendment context is the first step of the analysis. And I think that's what the court is saying. That's why the disproportionality principle, it assumes that this is really the legislature's realm. There are just very narrow guidelines and barriers over which the legislature can't cross. And this court said that. State versus Harris, this court, of course, adopted the controlling Harmelin opinion as a standard in Tennessee. And the court said, Reviewing courts should grant substantial deference to the broad authority legislatures impose in providing criminal justice sentences. That, I think, is what the court's getting at in Jones versus Mississippi, that these cases are disproportionality cases. And the first step in that analysis is a deference to legislative judgment, because these are ultimately really profound and difficult questions. How long is fair and just? And those are questions that are generally decided by collective judgment. Absolutely, there are lines that the legislature and that the people can't cross. But what the court is saying is, in Jones, I think specifically, that when it comes to boundaries beyond Miller, that we're going to leave those to the states. They said you could categorically bar life without parole sentences. You could provide a fact-finding requirement. Like you said, Justice Koch, there was a whole litany of options. And at the end of it, Justice Kavanaugh says, but the U.S. Constitution doesn't require any of them, because those are ultimately within the judgment of the people through their elected representatives and the legislatures.
How do we measure, your brief was very helpful to me on this point, the curious decision that the legislature made in 1995 to overlay H2 over H1, forcing this court to split the baby, and we come up with a very odd chronological analysis about what sentence length is going to be. I'm certainly not trying to prejudge it, but I wouldn't necessarily immediately say that makes sense.
And I'm sorry.
So if we're deferring to the legislature's judgment about length of sentences and all these sort of things, if one of the problems we have here is the sentencing structure, we're supposed to defer to that?
I just want to make sure I understand your question correctly. If the question is the sort of messiness, I guess, of the amendment, which the court discussed in Brown versus Jordan, which the court discussed in Brown versus Jordan.
For our purposes, we'll call it messy.
Okay, fair enough. I don't think that plays much. I don't think that plays much into the analysis. I'll be honest with you, Your Honor, because I think that's really just a question about the sort of Scrivener's quality of the communication of the judgment.
But Mr. Booker is caught between the cogs of that wheel, isn't he?
Well,
I mean, even you are saying you can give him relief by re-engineering the statute.
Well, Your Honor, I do not invite the court to do that. Now, the court, of course, ordered us
No,
to address what would be
you said it was an
available.
alternative. I know what your primary argument is, but there is a back door there.
Yes, I mean, and this goes to your point, I think, that you when you discussed with Mr. Harwell about sentencer versus parole, and I think it's clearly established at this point that if a state does have to provide a remedy, that the parole remedy is constitutionally adequate, that essentially solves the problem. In fact, there was criticism of the majority in Montgomery for saying that, because the point was you're basically just telling them get rid of life without parole. And so, I think ultimately from a constitutional perspective, if that's the route the court wants to go, that's certainly, I think, in line with these cases. When it comes to discretion to impose judgment, I think we have to start with the baseline that the baseline Eighth Amendment rule, legislatures don't have to give judges discretion to impose judgment, right? Except in those circumstances where the Eighth Amendment requires it. Death and life without parole for juvenile offenders. Those are the only circumstances in which legislatures cannot preclude discretion to impose a lesser judgment. I mean, these are really narrow limitations on legislative judgment. And I'm not aware of any case in which they've invalidated a sentence under this principle that's less than life without parole, which is what he's really asking the court to do. And I know
I would like to hear you address the argument under the classic Eighth Amendment Roper-Graham analysis in the face of national consensus objective data that shows that Tennessee is not just near the outer edge of the spectrum of sentencing statutes, it's at the outer edge. How would you apply both the objective indicia unusual component of the Roper-Graham analysis and then the independent judgment analysis?
Yes, and I'm going to answer your question. I just want to preface my answer with, and we've made this point in the brief, I think under Miller, based upon the type of rule he's asking for, that it's really not the appropriate test. But just putting that caveat out there, I'm going to answer your question. So when it comes to the Eighth Amendment analysis, I think the Eighth Amendment analysis and the Article 1, Section 16 analysis are different, because under the Article 1, Section 16 analysis, the court looks to state legislative enactments. I don't think the...
Let's just confine it to the Eighth Amendment for now.
Okay, fair enough. I don't think it controls the analysis that Tennessee has perhaps the most severe sentence here, and I would point the court to Rummel
Is it really
versus Estelle.
perhaps? It is the most severe. Would that be fair to say?
The only caveat I would give is Alaska, which requires 2/3 of 99 years. There is
But it also, that applies to a case with aggravating factors. In a case with no aggravating factors, Tennessee is at the outer edge of the spectrum.
I think that's fair to say. I don't know that the presence of the aggravating factors would resolve the constitutional question, because I don't know that it takes into
Mr. Booker's
account.
case has no aggravating factors, correct?
Correct.
Okay, go ahead.
I'm just saying, I think that when we're talking about the Miller rule, I do think that there's a question about whether those aggravating factors are constitutionally significant. But stipulating the point that this is the most severe sentence, that does not control the analysis. I would point the court to Rummel versus Estelle, in which the court said, some state will always bear the distinction of treating particular offenders more severely than any other state. It's not as if the Eighth Amendment analysis is one that just goes looking for what is the most severe sentence. I also think when he points to the national trend...
You would concede, though, wouldn't you, counsel, that the unusual component of that test is met?
No.
Even if the independent judgment prong is not. Surely you would concede that Tennessee's statute is unusual in its severity.
I would not concede that, Your
Okay,
Honor. I mean,
go ahead.
I think it's longer. I don't think it's so much longer that it's unusually long.
Okay.
You have states with a 40-year minimum, for instance, in Alaska that we've already discussed. And I would also note that when we look to these other states, we have to bear in mind, many of these states changed their laws after they were required to, right? The point of this analysis is to try to discern what collective judgment is. It's not as if these recent amendments to these statutes are some organic change in public opinion. These states are responding to the fact that their prior statutes were declared unconstitutional. So I think that in terms of a trend, it's really not as useful in a case like this.
Okay.
So the fact that the other states have followed their version of the Constitution or their understanding of the federal constitutions relevant?
I think when a legislature has to adopt a new statute because a court has declared their old statute unconstitutional, it's not as effective a demonstration of a change in public opinion, which is ultimately what we're trying to arrive at. And I would point the court to the analysis of Van Trant. See, in that case, the court in Penry had said it's not unconstitutional to execute the intellectually disabled. There were a number of states, including Tennessee, that changed that by statute when they didn't have to. And the court looked at that in Van Trant under the Eighth Amendment analysis and said that's an indication of evolving standards of decency. I think the change in this case and in these other states is much less compelling because they've had to adopt a new policy and they've had to go searching for things that would pass constitutional muster. And in fact, this was, of course, a hotly contested issue in Miller and in Montgomery and in Graham, that a lot of these states had already had a super majority of states had
Does
had
it
this
not
rule on the
say
books.
that the perception of these, clearly Miller, as you have pointed out, just applied to LWAP. Does it indicate that these legislatures perceived the line to be significantly below that of Tennessee's?
They did. I mean, I think that's fair to say that they,
Okay.
to the extent that they were making a policy judgment or they were conceiving of it as a constitutional line, I can't say for each of these individual states. It's likely one or the other, right?
Okay.
They're either arriving at it as a policy judgment or they think this is what's going to pass constitutional
Okay,
muster.
thank you.
So I certainly agree with that point. But I think my larger point is I'm not sure the trend tells us that much about what people think nationally, given those circumstances, given how different this is from the circumstances of Van Trant. And of course, with Tennessee, and I know I'm going to combine my analysis to the Eighth Amendment, I just want to point out that in Tennessee, based upon Tennessee enactments, there's simply no argument that the legislature has abandoned its judgment in this area. And then the second point, looking at the sort of grossly disproportionate analysis, right, is this...
The independent judgment prong of that analysis?
Is this grossly disproportionate? This is a murder case. Life without parole would not be grossly disproportionate so long as there was an individualized circumstance with the consideration of youth. I don't think it's fair to say that this is grossly disproportionate when it is less than that. And we can fairly debate, I think, what the appropriate outcome in any individualized case is, and especially with a juvenile offender. But that doesn't change the fact that a life was taken. And I think it is appropriate to impose a very severe sentence for that. There was something I was reading. I supplemented the court with the United States versus Friend, which is a Fourth Circuit case.
You can still impose a very severe punishment if there's been some individualized decision that the severe punishment is warranted in the particular case, can't you?
Absolutely. Yes, absolutely. That is true.
I think that's one of the things that we have to remember is that notwithstanding how we interpret the Supreme Court's opinions, it's very clear that the United States Supreme Court does not believe that life without parole for a juvenile has an Eighth Amendment problem as long as there has been an individualized decision, right?
Yes, absolutely.
And so aligning the statutes is addressing that with a meat axe, isn't it?
Well, and Your Honor, my response is, and this goes back to the caveat that I made at the beginning, I just don't think the question about mandatory versus discretionary really fits or grafts easily onto this analysis that we're talking about now, which is why I've taken the position under Miller that it's not the appropriate analysis. I think that's right. I also think that that's purely a judgment, or not purely, but that's a judgment that the legislature can make too, right? Is what's the minimum discretion we want to give? And so under that framework, the question is...
Under the due process clause, courts have the prerogative to determine what process is due in light of the circumstances, don't we?
Yes. Yes. I don't think this is a due process issue. I mean, I think this is really just an Eighth Amendment issue. In fact, I think that, that's the issue that the court took review of, is does this violate the Constitution, because he raised an Eighth Amendment question. So I'm not really sure this is a due process issue, and I don't think that a mandatory sentence in principle or in general ever raises a due process issue.
I'm alluding to the Matthews versus Eldridge three-factor balancing test to determine what process is due, which certainly this court's applied in the criminal context.
And I think the defendant had all the due process owed to him. I mean, look, the Supreme Court has in these very cases countenanced sentences that provide a mandatory minimum service term.
Yes, I agree. But part of the essential element of fundamental fairness is that you employ a process that minimizes the risk of mistake, because it's a bad thing when the government makes decisions based on erroneous information. Wouldn't you agree with that?
Sure, yeah, absolutely.
Well, isn't that in some ways applicable here, that what the courts are saying is sentence the juveniles to as serious a sentence as you want, make sure your process minimizes error.
I just don't see this as error. I think if the legislatures come to the judgment...
Or it minimizes a disproportionate punishment.
And that brings us back to Montgomery and to Miller. And my point is that under that framework, we're back with the proportionality principle, an extremely narrow principle that is very rarely successful. This court said that in State v. Harris. Very exceedingly rare, I believe, was the phrase.
If we were to remand the case to the trial court and say that, Mr. Booker, we need to insert discretion into the trial court's sentencing decision because Mr. Booker was a juvenile at the time of the offense, how would that play out as to other juvenile offenders?
As to other juvenile offenders, I'm sorry, was that the question? Like other cases?
Yes.
Okay.
As to juveniles who are currently incarcerated for first-degree murder under the statute that's at issue here.
I understand. So I agree with Mr. Harwell. I think we get to a sticky question about retroactivity there, especially in light of what the court in Jones said about Montgomery. So whether or not they can obtain relief, assuming, for instance, that they're past direct review, they're past post-conviction, or in post-conviction rather, is it a new rule of law? Is it retroactive? I think that's a really, really difficult question that the court would ultimately face, inevitably, because of what the court did in Jones with Montgomery, in which it said, don't even really cite Montgomery for its retroactivity analysis again. So the consequence it will have is really going to depend on future litigation. I'm not trying to be evasive to your question. I just think it's really difficult to say, and a lot of it depends on how the court decides the case, right? What kind of language the court uses, whether the court suggests it's a new rule at all, or if it's dictated by precedent, that kind of thing is really what plays into that analysis. Hard for me to say standing here. Again, I apologize. I'm not trying to be evasive. That's
No,
just my
I'm-
honest
I've-
answer.
I've asked
It's a
you
separate
cold.
case, right?
Right.
They'll have to file a petition, and it's a separate hearing. Well, how would it, if we remanded for an individualized sentencing hearing, how would that play out for Mr. Booker?
I'll be candid with the court. I thought about advocating for that. When the court instructed us to advocate for, what are the potential options, I thought about advocating for, just remand it for a hearing, because if the problem is it's mandatory, then it's not mandatory. The reason I didn't do that is a little bit of practicing what you preach. Because I thought if the court's going to impose some sort of discretionary sentencing procedure, it starts to look a lot like legislation. And that's why I didn't advocate for it, is because what I was suggesting to the court was that it used the tools already available to it. I'm not aware of a circumstance in which the court has done anything like that. I will say this. This is essentially what the court did in Alabama after Miller versus Alabama. Now, it was a little different because that was an actual life without parole sentence. So there already was a lesser life without parole sentence. But what the court did was essentially allied the mandatory provision and open up the ability to impose that lesser sentence of life with parole.
If it goes back for a remand, say, under the current statute for individualized sentencing, what would be the parameters? I guess I'm not sure. As a trial judge, how would I say I decided that there were certain matters that dictated a lower sentence? What would be my parameters in doing that under this current situation?
So I'm gonna give you two answers. The first one is constitutionally, and I think under Jones, it just has to be that he can consider, or she can consider, the age of the defendant in the process of making that discretion. I don't think these factors, some of the factors, Mr. Harwell, I don't think there actually is a requirement of specific factors. I think the discretion is enough. So long as they have the ability to consider youth, they don't even have to say it on the record constitutionally. In terms, I think, of more of an approach consistent with our statutes, if the court afforded discretion there, then I think the sort of normal purposes and principles of sentencing, that the bystander, right? I mean, I think that those sorts of factors and principles and all of those things would come into play once the court's exercising its discretion.
Could the trial court say, you've been here, you've been serving 10 years, I think that's enough considering your age. Pack up and leave.
I think it would
that work?
depend. I think it would depend on what the court granted them discretion to do. So if the court granted them discretion to impose the old sentence, then the minimum would be at least 25 years, right? It would just be a question between life and pre-1995 life and post-1995 life. Now, if the court crafted some new available sentence, that's a difficult question for me to answer without knowing what the court would adopt. And these are the sticky questions, which is why I chose not to advocate for this as a response, because you start to unpack it and there's a lot of layers there that get pretty tricky.
Yeah, I mean, it seems truer to Miller to do it that way, but how does that really work? It's the thing.
And I think, and ultimately, I think that, and if the court were to declare it unconstitutional, I think ultimately the legislature would have to have something to say about that. There's probably a way to craft it, but I do think it gets quite difficult. And I will just say one more thing about this in response to something Mr. Harwell said, which is ex post facto. I'm not really sure what the ex post facto theory is. I think this is coming from his suggestion that the court reanimate the old statute. I think if the court aligns it the way that I suggest, it doesn't really raise ex post facto questions. I'm sure that's an issue that perhaps Mr. Harwell and I will litigate down the road if the court goes down that route. But I don't see any obvious ex post facto issues there.
And may I just follow up on that? And again, your brief was very helpful on this point. I haven't gone back and listened to the legislative debates on this wonderful statute from 1995. But what reason do we know, we may not, why would they have just engrafted H2 on the top of H1?
I think, you mean from a policy perspective or from?
Yeah, I mean, did they explain what their intention, what their purpose was?
My recollection is that this is like a truth in sentencing bill, effectively. That this is an idea about, this was a period of time, and the court discusses this, or excuse me, not the court. Chief Justice Roberts discusses this in his dissent in Miller versus Alabama. Beginning in the 1980s, this was a time period in which states increased sentences across the board. States started to move away from parole and towards truth in sentencing. Tennessee was not unique in that respect. Tennessee may be unique now with respect to how long this is.
Maybe I'm just, I'm not getting it. That's why I'm looking for your help. They could have just passed H2 and repealed H1.
I think that the thought there was perhaps that is an ex post facto issue that they were trying to avoid, was that the idea of increasing the period of parole eligibility from that point for somebody who had already committed an act and been sentenced. Maybe they were afraid of that. I just know, just by virtue of thumbing through the code frequently as I am called to do, very, very common for the legislature to do that, where they just say effective date of the act, all acts committed after that. They do that in this context, outside of the first degree murder context, in terms of parole eligibility and all. They do that routinely.
But theoretically, there could still be a murder out there from before July 1 of 1995, right? There's no statute of limitations on murder, so that's why H1 is there.
That's absolutely right, which is effectively what the court said in Brown versus Jordan. Your Honors, I see my time is up. I'm happy to answer any further questions. And Mr. Chief Justice, if I could just make one point before I step away.
Go ahead.
Okay. Thank you. Like in Jones versus Mississippi, this is not the final word for Mr. Booker. There are other avenues in the legislature and with the governor for this sentence and these policy questions, in my view, that have been raised to be addressed. And I would commend to the court the closing paragraphs of Jones versus Mississippi and its reflection on these constitutional issues and the moral and social policy questions that they raise. Thank you very much.
I think I have 4 brief points. One to follow up on some questions, Justice Koch, you were asking about the legislative decision. I think the crucial fact here, and this is one that was alluded to in Miller, is when we're thinking about our scheme, we don't have a single decision where the legislature decided we would like a juvenile convicted of felony murder to be sentenced to 51 years prior to release. We instead have a series of decisions, a transfer statute, then the revised code providing 60% of 60, and then this decision in the mid-90s to raise as a blanket matter release eligibility. My understanding is that was directly connected to availability of federal funding for prisons, that the 94 crime bill required that states have 85% release eligibility for certain violent offenses, or they would not receive federal money. And so I think that's what the legislature was complying with, why it went down in such a blanket fashion. Unfortunately, I think that money no longer comes, but we were stuck with that statute. But the point here is we're not talking about any time in our history where the legislature has debated should juvenile felony murder defendants get 51 years. We just have a accumulation of different decisions.
Well, but they know that's been happening and they haven't done anything to fix it, correct?
That's fair as well. The second point I want to make, and I wrote it down to make it, although Justice Kirby, I think maybe you made it better than I did. All of these states that the state was talking about that had a Miller problem, it is instructive that none of them thought that the solution to the Miller problem was to add a 51-year option. And that contributes both to the survey of contemporary standards, and it also is a suggestion certainly of how other courts and legislatures view the scope of Miller. The third point I want to make, and the state has said in the briefing and again in argument today, that this meaningful opportunity language that I've highlighted from Graham was not repeated over and over again in Miller. That was only referenced once. And that is true, except it is referenced immediately after the most important sentence in Miller, where the court says, "We therefore hold." And that's when they cite the quotation from Graham on meaningful opportunity for release. So I don't think it's accurate or fair to indicate that Miller is stepping back from that Graham elaboration of the issue. And the final thing I will say, I think, is to respond to the state's suggestion that Mr. Booker has many other avenues. Mr. Booker does have some other avenues. But the avenue for determination of the Constitution of the state of Tennessee, that comes right here. And the issue is squarely posed to this court, whether this system that disregards, we have all of this information. We had no opportunity to be heard on all of this information. This system that disregards any of our notions of individualized sentencing, disregards our notion that children are different. The avenue for determining whether that is a constitutional problem comes to this court, and this case squarely presents that issue.
So I have a question. The state indicated that your second argument, that the Roper-Graham analysis should apply, is not appropriate in this case. And if with the indulgence of the Chief Justice, I'd like to hear your response.
Sure.
And my response is that it is. I know the state has claimed that. I have not quite understood. The state cites to something in Miller, and I don't understand the effect of that argument. It's an Eighth Amendment Article 1, Section 16 claim. Black says this is how you conduct those claims. You look at these three prongs. We have other cases applying that same analysis. It seems to me to be clearly the right way to go about it.
Okay, thank you.
Thank you, Your Honors.
Thank you for those fine arguments. We'll adjourn. We'll be back here on April 6th.
All rise. This honorable court is now adjourned.